following judgment, which I shall deliver on the legal questions presented, is the judgment of the court which both of its members have contributed. There is before the Supreme Court on this occasion an appeal against conviction brought by Mr. Byng in respect of his conviction for the murder of his very young son Ross, and also an appeal against the conviction of a medical practitioner, Dr. Geller, for murder, appeal against the conviction for murder of another baby, Joey, whom she removed from a life support machine which she felt, in her judgment, would better be deployed to sustain Ross's life, although in the due course of events, unfortunately, Ross also did not survive. At first blush, it may well appear to the ordinary observer, it seems to us, that neither of these cases is what would be termed a typical case of murder. But the jury convicted both Mr. Byng and Dr. Geller, and they have appealed to the Court of Appeal, which dismissed both of their appeals. They therefore appeal with the leave of this court to this court against their convictions. The course of the appeals necessitated our consideration of a large number of authorities, principally the authority of Woollen, decided not by this court but by its predecessor, the Appellate Committee of the House of Lords, in 1998, and the conjoined twins case, otherwise Re-A, a decision of the Civil Division of the Court of Appeal, then comprising Lords Justices Ward, Brooke and Robert Walker, but it is apparent from that judgment that the Court of Appeal considered the implications of the criminal law so far as the scenario then presented, and it is not therefore a judgment restricted to principles of civil law, and it's certainly been of assistance to us in the consideration of the issues presented in this case. It is said by the appellant, or by the appellants I should say, represented respectively by Miss Rebecca Neville and Miss Wales before us, that the learned judge's directions in respect of Mr. Byng were inadequate. At Mr. Byng's trial, the direction which the learned judge gave was that if the jury concluded that it was a virtual certainty that Ross would die or suffer really serious physical harm as a result of being thrown from the window, and that Mr. Byng must have been aware of such a risk, they were entitled to convict him of murder on that basis. It seems to us that the learned judge strove in the course of his directions to follow the guidance offered by the Court of Appeal in the earlier case of Nedrick, and with some revisions approved by the House of Lords in Woollen. It seems to us, however, that Woollen is rather a bad fit for the circumstances that pertain in this case. Mr. Woollen, it cannot be said, was seeking to avoid injury to his son in the way that everyone, including the prosecution, accepts Mr. Byng was seeking to do. Mr. Byng was confronted with a very difficult choice, which none of us would wish to make. If he remained in the flat with his two young children, it seems it is inevitable that all three of them would have died in the fire. His action in throwing his son out of the window caused his death, the son's death, but it preserved both Mr. Byng's own life and that of his daughter. Counsel for the respondent, Mr. Shirley, has sought to persuade us that there were a number of alternative courses of action that would have been available to Mr. Byng, that he could, for example, have thrown a mattress out of the window in order to cushion Ross's landing on the ground beneath, or that he could have waited longer than in fact he did, by which time perhaps the emergency services would have arrived. As we understand it, Mr. Shirley submits that the learned trial judge's direction emerging from the case of Woollen was accurate, and since there is no clear statement of whether or not the issue of necessity was one upon which the judge directed the jury, we should assume that he dealt with it properly and that the verdict is safe. The issue which concerns us is that since Woolen was decided, there has been a certain amount of lack of clarity in the Court of Appeal as to whether Woolen is properly understood as enlarging the mens rea requirement of murder to include circumstances not only where death or serious injury is desired, and in that sense intended by an individual, but also where it can be proved that even though they did not desire any such result, the individual acted in appreciation that it was the virtually certain consequence of their voluntary act. And we have been referred by counsel for the appellants to the authority of M&D, which demonstrates, in fact it's the authority of Matthews and the Lamb Court of Appeal case presided over on that occasion by Lord Justice Riggs, which demonstrates that at least that composition of that court were under the impression that Woolen direction was merely a mechanism, a lens, if one will, through which a jury could view evidence so as to infer from it an intention adequate to the mens rea of murder. The Woolen decision plainly was designed to clarify an area of the criminal law which had become very muddled, and it's apparent from the history of the authorities on this issue, Maloney, Hancock, et al., that there was disagreement between their lordships at that time as to whether the appropriate risk was severe risk, virtual certainty, or a number of other formulations. Despite the fact that Woolen is now settled authority, has been in existence for some 14 years, it seems to us that the circumstances of this case demonstrate that it has its own shortcomings. The council before us were asked to address the issue of whether or not the decision added an extra element to mens rea, or whether or not it was merely an evidential lens through which the jury could be invited to view the circumstantial evidence such as to conclude that there was intent sufficient for murder. And we were intrigued to note that senior counsel for the respondent, Mr. Shirley, in fact conceded that the latter was the case. It seems to us that it is at least arguable that in fact the former is the case, and that Woolen is properly construed as enlarging the mental element of murder and not contracting it. Enlarging the mental element of such a serious crime, which continues to this day to carry a mandatory sentence of life imprisonment, seems to us an odd state of affairs. It seems to us that it's necessary in those circumstances to revisit the correctness of the decision in Woolen, and to acknowledge that in seeking to substitute the words to find for to infer, as Lord Hope did in his short speech at the end of the judgment, there continue to be problems, practical problems, with its application. Those problems are thrown into stark relief in circumstances such as these. It does not seem to us to be sustainable that Woolen is sufficient to fix an individual with criminal responsibility to the level of that necessary for murder, when it is plain, indeed accepted by the prosecution, that Mr. Bing's intention was the exact opposite, or to achieve the exact opposite of what he in fact achieved, not merely not to endanger life, but indeed to preserve it. It seems to us that in those circumstances, it is clear to us, although it is not clear whether or not the issue of necessity was properly explored in the lower court, that the learned judge's directions emerging from Woolen were inadequate. And in those circumstances, it must inevitably flow from that conclusion that the conviction of Mr. Bing for murder is unsafe. In those circumstances, we have no alternative but to quash it. We have been urged to consider by Mr. Shirley the possibility of ordering a retrial, and no doubt a retrial could proceed in such a way that one could be quite sure that any jury was properly directed not only on the ingredients of Woolen, the test expanded in Woolen as we have modified it, but also on the issue of necessity. We do not feel that the circumstances of this case, tragic as it is in the extreme, mean that a retrial is in the public interest. We therefore quash Mr. Bing's conviction, and we do not order any further proceedings against him. There is, it seems to us, a tension between the respondent's contention that there would be available to Mr. Byng a defence of necessity, or may have been on these facts, when such a defence is not said to have existed for the benefit of the medical practitioner, Dr. Geller, who chose to remove Jodie from the life support machine and put Ross inside it. That was not a choice which she herself sought or invited, but one which sadly and mercifully infrequently medical practitioners are required to deal with. A similar set of circumstances arose in the conjoined twins case, the celebrated case of Re A. It seems to us that there is not really any meaningful distinction to be drawn between the facts that arise in this case and those which pertain in the case of Re A, although it is, of course, right to say that the facts were not by any means identical. There were, in both situations, competing rights to life. And it seems to us that to refer to the passage in the judgment of Lord Justice Ward, which I referred to during the course of argument, that a medical practitioner confronted with that dreadful dilemma cannot be denied the right of choice when they are under a duty, as we find Dr. Geller was, to make a choice. She did not, as I say, invite circumstances in which she was required to make that choice, but it seems to us that if the reasoning in Re A is sound, then her actions must inevitably be lawful, notwithstanding any recourse that she may or may not have had to any court of law. The doctors in Re A had the luxury, and I do not use that word in any flippant sense, of having sufficient time, not a very great deal of time, but sufficient time to ask the court's opinion of the lawfulness of their action before they performed the operation, which tragically, whilst preserving Mary's life, I'm sorry, I think it's Jodie's life, would inevitably lead to the death of her conjoined twin, Mary. Those circumstances, unfortunately, did not pertain in Dr. Geller's case, but as we understand it, the Court of Appeal and Re A were not saying that this act that would otherwise be unlawful is by our decision rendered lawful. They were saying that in those very unusual and unfortunate circumstances, the act, though it would inevitably bring about the death of one of the conjoined twins, was, because of the overbearing interests of the other, a lawful act and one which the doctor could properly perform. It seems to us, therefore, that the learned trial judge's directions in respect of Dr. Geller's case were inadequate. He removed from the jury's consideration any element of necessity, and it flows, therefore, it's inevitable, of course, as a result, that the jury felt compelled on his direction to find Dr. Geller guilty. It seems to us, therefore, that we have no alternative but to reverse the Court of Appeal's decision to quash Dr. Geller's conviction. Again, it seems to us that there is no compelling public interest to warrant Dr. Geller's retrial, either on the charge of murder or the charge of manslaughter, and we therefore simply quash her conviction also. So both these appeals are, for those reasons, briefly stated, allowed. Right, that's a serious bit over.
Yes, that's the point at which Lord Richard's the 13th Supreme Court Justice becomes Allen. May I thank you first of all for having us back again. The abiding imprint I have on my retina from last year isn't the shock on the faces of the four people in front of us when Alan invited them to consider submissions in relation to a retrial. I see Emma in the front row. Professor Leopold rolling her eyes in sheer disbelief and outrage that had been merely suggested. So thank you very much for having us back. It has been an honour, as it was last year. And the standard, I should say, is equally high this year. It's highly impressive indeed. Taking subject matters through step by step, first of all, the preparation was clearly second to none here. You had to contend with a highly complex judgment in Re A, where the density of legal principle was almost unparalleled in terms of what one has to deal with in practice, particularly Lord Justice Brooks' judgment. Very complicated indeed, and you handled preparation clearly very well. Delivery was impressive. Eye contact is crucial when you're dealing with any tribunal. Your eye contact was very good indeed. You didn't have any nervous tics at all. Half of bar school is spent beating nervous tics and irritating habits out of one, and you will go to bar school or law college without having to have anything beaten out of you in terms of style. Posture equally was superb from all of you. Didn't notice anything which would have caused a judge irritation at all. Etiquette was also very good indeed. It's worth pointing out that no practitioner who doesn't regularly appear in the High Court or above can satisfactorily deal with nomenclature of judges. And you'll hear people calling High Court judges the wrong thing all of the time, whether it's Your Honour or My Lordship. But importantly, when you're addressing a judge directly, you say, My Lord, as Your Lordship knows. And if you get that into your head beforehand, and even right when you're in front of a High Court judge, My Lord, at the top of the page, you can't go wrong. Responses to judges' questions, immeasurable difficulty in these circumstances, particularly given the fact that I understand that one team is first year. It's absolutely staggering to be able to deal with judicial intervention in the way you have, because it's never easy at all. In practice, it's always worth bearing in mind that you're in front of a human being, and it's always worth bearing in mind that you, like they, can control the pace. And if you slow the pace right down, then the judge has to follow suit, except in the case of certain Lords Justices of Appeal. But ordinarily, by slowing the pace down, you begin to take control. You can then listen to the question. You've got the luxury of being able to listen to the question. You can always ask the question to be repeated, particularly when it's particularly long and complex, with grammatical structures that one doesn't come across in ordinary life thrown in for good measure. But it is important to be able to understand the question. It's important to be able to say, I'm afraid I don't follow that. Can you break it down so that I can deal with each point individually? Because there is no shame in saying I don't understand. Break it down, and then I'll deal with each point, and then you can enumerate them and deal with them bang, bang, bang. Never assume that a judge is leading you in a particular direction through a question. It's always worth standing back from it and thinking, actually, what is my answer to this question in the context of my argument? Because otherwise you can be led down a road into a trap, particularly where you've got a judgment like Lord Justice Brooks' judgment, where you have a series of examples, and they're particularly complex moral examples. And if you start nodding away to the suggestion that an example might be right, then you'll find yourself being led down to a conclusion which doesn't suit the case at all that you're trying to propound. So overall, absolutely fantastic from both teams. We've had to make a decision tonight, and it's been a very close, agonising decision. It has to be said that just by a thin margin, the respondents' team wins. But we understand, as we said, that one of the teams is a first-year team, and I dare say it's the two ladies, because one can tell actually that on my left they've acquired a deal of maturity, presumably from doing this for an additional year. So it's clear from what we've got in front of us there's massive potential, and indeed a darn sight more talent than one sees in Crown Court and County Court hearings on a day-to-day level. And that said, hand on heart, one sees some advocacy which doesn't come close to what we've seen this evening on a day-to-day basis. So it's very, very impressive indeed, and you will deserve a round of applause.
Can I thank Ben, Douglas Jones and Alex Richards for giving up their valuable time and being such fantastic support and so entertaining. Round of applause, please. Now, I think we'll just whiz through some presentations because I suspect you, like me, are hungry. So Can I call
Joanne, don't worry about it.
I'm representing one club to present the certificates
Thank you very
and
much.
book vouchers.
Okay.
Now, does anyone have a fancy phone camera on their phone?
Christian's got
I've got my big camera if you want.
So I have one for Amy. Congratulations. And just to reiterate what's already been said, I really hope you do this again next year, because I think by this time next year you'll be absolutely unstoppable.
Thank you very much.
Well done. Fantastically well done. I'm looking forward to seeing one of you, I'm not sure which yet, in Osborne Park for your week's work experience. I hope you enjoy it.
Thank you very much.
Well done. You were very impressive tonight. Congratulations. Thank you.
Have some photos with the judges, perhaps. I don't know whether